So hello everyone, today we're going to be doing the part 2 of the legal services and guidance on the asylum process, and this briefing will be covering what happens after your big substantive asylum interview and how to understand both positive and negative decisions that you might receive regarding your asylum claim. After the substantive interview, it's really important that you keep the Home Office and your legal representative up to date with your details if they do change. And a letter may be sent to you directly confirming the outcome of your case. So you can update the asylum teams via your legal representative, or you can update it at your reporting centre or online via the visa address update website that you can see here on gov.uk. It's important that you continue to report to the reporting centre while you're waiting for your asylum decision in line with your reporting conditions. If the Home Office has not made a decision on your asylum claim within 12 months or has not interviewed you yet, then you can apply for permission to work. This may be granted if you are not considered responsible for the delay in the decision making of your asylum claim. Now, any permission to work stops once the asylum claim has been determined. So if you're granted with permission to work, you'll only be able to partake in employment that is on the shortage occupation list. So this is a list of work that you are allowed to do. And that's available on the Home Office website, as you can see over here. Any income may affect your entitlement to asylum support and legal aid, and you should inform this to the Home Office support teams and your legal representative if you do start work. Now, as an asylum seeker, you are allowed to volunteer while you're here in the UK, and you can volunteer within the public sector, charities, but there might be some restrictions on what you can actually do in your role. Now, you cannot receive payment for your time, but you can be reimbursed expenses, for example, your travel costs and lunch. What to do with a positive decision? Now, if you're granted refugee status, your support will stop in 28 days and you must leave your accommodation. You will need to transfer from asylum support to mainstream housing and welfare and look for work if you are able to. Now, you should be sent 4 documents. That's your status letter, which will advise you that you have been granted status, your discontinuation letter advising your asylum support will come to an end, your notice to quit letter or the NTQ advising you to leave your accommodation on a specific date, and your biometric residence permit, also called the BRP. This should include your national insurance number as well. Now, you need these documents to be able to apply for housing, benefits and work. Your details will be passed to Migrant Help by the Home Office once your asylum support is discontinued, and Migrant Help can provide you with move-on advice to assist you to move on from asylum support. And Migrant Help will be in contact by telephone to offer our Move On service. If you confirm that you would like our assistance, an appointment can be booked with one of our Move On providers. Our Move On providers will contact you to provide guidance on how to access mainstream benefits and housing in the UK, as well as guidance on employment if you are ready to have a job. They will also give you information on useful services in your area, which may help you settle into your local community. So, biometric residence permits, also known as the BRP. So your BRP is your right to stay, work and study in the UK, and you will need to use this as a form of ID. Now, your biometric card will be posted by secure mail to either you or your legal representative. It's really important that you check that all details are correct on your card. You must report any mistakes to the Home Office. Please aim to do this within 10 working days once you've noticed that there has been a mistake. And you can do this by going on the gov.uk website on the Biometric Residence Permit section to log any issues, and the website, we've also included the link over here. Now, your legal representative may also be able to assist, and if your biometric card is lost or stolen, you must report this to the Home Office as soon as possible. The Home Office will then need to cancel your card. So again, you can go on the gov.co.uk website and on the BRP section to report that you have lost it. Family reunion. Once you have been granted leave to remain, you may be entitled to apply for a family reunion visa for your close family. So this includes your husband, your wife, your partner, your dependent children to join you in the UK. Now, your partner or child may be able to join or stay with you in the UK if you were a part of a family before you were forced to leave your country. You have refugee status, so you have refugee status, 5 years humanitarian protection or settlement on protection grounds, but don't have British citizenship yet. If you're granted status, this is a conversation you can have with your legal representative who will advise you of the process. Now, what to do with a negative decision? So if you have been refused asylum, it means that the Home Office assessed your case and found that you did not meet the criteria to be granted refugee status or protection on other grounds. So, for example, humanitarian protection and discretionary leave. Now, your case could be a certified refusal. What this means is the Home Office doesn't believe that there is a risk to you and that state protection in your country is fine. This means that your case has been certified as clearly unfounded, which basically means that it is a very, very weak case, and it's pretty likely that you will be detained and you will be removed on fast track basis upon entry to the UK. Generally, you won't have in-country right to appeal, so right to appeal while you're in the UK, and so you could become appeals rights exhausted. But you are, however, able to appeal once you have left the UK, also known as an out-of-country appeal. And you may be able to apply for a judicial review, and we'll explain what a judicial review means a little bit later. You will need to discuss this with your legal representative. It's only your legal representative that can apply for a judicial review if there are grounds to do so. Now, it is important to contact your legal representative as soon as possible after you've received a negative decision to ask if and how they will support you. So, a little bit about in-country right of appeal. It is likely that your case will be refused with a right of appeal. Now, appeals are submitted and heard by what's called the First Tier Tribunal Immigration and Asylum Chamber. The tribunal is independent of the government, and a judge will listen to both sides of the argument before deciding on whether to overturn the Home Office decision by granting you status, or if they have the same findings as the Home Office and refuse the appeal. Not all immigration decisions, however, have the right of appeal. There is currently only the right of appeal within the UK if the Home Office refuse an application based on an international protection claim, a decision to revoke refugee status or humanitarian protection, a claim for the right to remain in the UK under EU European law, a human rights claim, and not all applications based on human rights or protection grounds do have a right of appeal. Now, you may have the right of appeal against a refusal while you're in the UK, and you must do this within 14 calendar days of your refusal letter. If you're refused asylum with no right to appeal or do not use your right of appeal, then your asylum support will stop in 21 days from the date given on your asylum decision letter. Legal representation following a refusal. Now, if you do get refused on your asylum claim, your legal representative will assess your case and decide whether they can keep helping you. So what they might do is they may continue to help you with your case if they can show that your case has a good enough chance of success. They may submit your appeal form to begin the appeal process and then stop assisting you any further from that. Or they might stop assisting you if they deem that your case does not have a good enough chance of success. Now, you may be able to challenge your lawyer's decision to stop assisting you further, and you can do this by visiting Legal Aid Agency Appeal online. If your lawyer will not represent you, you can represent yourself throughout your appeal hearing. Now, appeal hearings are heard at the HM Courts and Tribunal Service in the Immigration and Asylum Chamber, also known as IAC for short. There are a number of courts in the UK, and you will be notified which court your hearing will be taking place. And once your appeal has been submitted, there are 2 tribunals, a first tier tribunal and an upper tribunal. Once your appeal hearing date has been set, you'll receive a letter confirming the date, time and place of your court hearing. So what to do before the hearing? Now, many people's hearings are open, meaning people can sit in on them. Sitting in on someone else's case may help you to get a feel for the layout, what happens in other cases, and what the experience may be like for you and give you a feel for it. Though, of course, it's important to note that it will be different for everybody. Now, if you have young children, you can ask your friends, family, and the community for help. You might also want some emotional support on the day, so you have people who can attend and sit in the public area of the court. They'll not be able to intervene, but moral support might be good for you if you are feeling nervous. Video hearings. So the first tier tribunal hearing centres are operating a reduced number of face-to-face hearings due to the current coronavirus pandemic, and many hearings are taking place remotely, either by telephone or video. You should not go to a court or tribunal building unless you have been told that your hearing is going to take place in person. Now, parties and representatives will be informed as to what the arrangements are for your hearing cases. Any other person interested in joining the hearing should contact the relevant hearing centre directly so that arrangements can be made. So hearings of appeals and judicial reviews in the upper tribunal, Immigration and Asylum Chamber are currently taking place in courtrooms which are also open to the public. This includes where the hearing is being conducted by remote means. For example, different arrangements may apply for case management hearings. For details on accessing a hearing, please email supporttribunal listing team at justice.gov.uk. So, face-to-face appeal hearing. Now, if you are invited to a face-to-face hearing, when you arrive at the courthouse, known as the Tribunal Hearing Centre, you will go through a security check. Now, you must tell the receptionist or the clerk that you have arrived, and you'll then have to wait until your hearing takes place. Your case may be listed as 10 a.m. on the date you were given your notice of hearing, but the judge will decide on the order of all of the hearings on the day. So you may therefore be waiting a long time for your hearing. Therefore, you might want to bring money or some refreshments with you so you can buy refreshments, but you should be offered water while you're in the waiting room. You will be called into the hearing room by the clerk. If you have any witnesses giving evidence, make sure the clerk knows that they are present. When you go to court, you will be seated in a room with the judge, the Home Office, and the Home Office representative who will present their case to the judge, explaining the reasons why you have been refused and why they don't believe that you meet the definition of a refugee. You or your legal representative, that's if you have one, must then respond to the Home Office's case and present the reasons you believe that you do meet the legal definition of a refugee. The judge will assess both sides of the case and decide whether you should be recognised as a refugee within the Refugee Convention, or are you entitled to humanitarian protection or some other kind of leave to remain. The judge may also decide that the Home Office decision to refuse your case was correct and therefore dismiss your appeal. The judge will not make their decision on the day of the hearing, and instead the judge will go away to think about your case and will then send their written decision with reasons to you or your lawyer if you have one, and the Home Office. You should also be given an interpreter. Now, please ensure that you're happy with the interpreter that you are given. If you're not happy, you will need to request an alternative interpreter, or a delay, also called an adjournment. Now, what this is a postponement to your hearing, which may be requested by the Home Office or your legal representative with reasonable explanation. It is also absolutely fine to ask for any explanation of any court procedures. So, human rights. Now, the judge will decide about other elements of your case. They will decide any human rights issue that would entitle you to protection in the UK. This kind of consideration is based on the European Convention on Human Rights. If the judge upholds your appeal on human rights grounds rather than refugee grounds, then you'll be granted 5 years leave to remain through humanitarian protection rather than 5 years refugee leave to remain. If the judge decides you have a right to stay because of your private or family life in the UK, you will be granted 30 months leave to remain. After the hearing. Now, you'll normally receive the decision within 3 weeks of your full appeal hearing. If the judge grants you asylum, you will receive the same status and the same rights as if the Home Office had originally granted you asylum when you applied for it. However, the Home Office do have 14 days to decide whether to appeal the judge's decision. What if you're refused at first tier tribunal? Now, if you're refused by the judge at first tier tribunal, you must ask the first tier tribunal for permission to appeal to the upper tribunal. What that means is the higher court. This needs to be done within the UK and within 14 days after the date on the written reasons for the decision. You must be able to make the case why it is legally wrong, which may include that they did not apply the correct law or wrongly interpreted the law in your case, didn't follow the correct procedures in your case, or had no evidence or not enough evidence to support their decision on your case. If there has not been an error in law, it is likely that you will become appeals rights exhausted at this stage. If you have a legal representative, they will assess your case and see if they think that such an appeal is possible. The first tier tribunal will assess this request. Now, if they say no, then you are entitled to make your application to the upper tribunal for them to make a decision themselves. This renewed application must be submitted to the upper tribunal no later than 14 days after the first tier tribunal's decision not to grant permission to appeal was sent to you. if the first tier tribunal or the upper tribunal grant you permission to appeal, the upper tribunal will notify you and your lawyer, if you have one, about how they will proceed and whether they plan to hold any hearing which you or your lawyer, if you have one, would need to attend. Judicial reviews. Now, earlier I said we would come back to judicial reviews. Now, if you have no right to appeal to a tribunal judge, you may still be able to challenge a negative decision with a judicial review, but this process falls outside of the asylum process, and it assesses whether the Home Office decision-making process and their application of the law and the application of the appropriate law, on your case. So there must be a proof of an error in law. This is usually made at 3 main stages. Certified refusal, for example, if certain information hasn't been taken into account. Further submissions for fresh claim. For example, the Home Office refused to treat your submissions as this, and so the legal representative may believe that there is grounds for further submissions that hasn't been taken into account by the Home Office. Refusal at upper tribunal. Now, judicial reviews are very, very complicated, and it is recommended that you seek legal advice if you are thinking about asking for one. What are fresh submissions and fresh claims? Now, we spoke about this earlier, but what does this mean? Now, further evidence may be submitted if you have been refused asylum after you become appeals rights exhausted via the Home Office in Liverpool. When a human rights or protection claim has been refused or withdrawn or treated as withdrawn, the Home Office will consider any further submissions. If rejected, they will determine if they amount to a fresh claim. If the application is being treated as further submissions, then it could be refused, so you will be granted no grant of appeal. If accepted, you will be granted a right of appeal. If you appeal, the appeal will then be heard in the first tier tribunal. The Home Office may decide to grant you status after assessing your case. For further submissions to be accepted as the basis of a fresh claim, they must be new evidence to support your original claim, significant information that the Home Office could judge to have a serious impact on your case, giving your case a realistic prospect of success, changes to UK law, policy or country guidance, information not previously available to you, and any change of circumstances in your home country. Further submissions should be made as soon as it is reasonably possible. Finally, negative move-on advice. Now, here at Migrant Help, we can provide you with move-on advice to assist you to move on from support following a discontinuation of support. Your details will be passed to Migrant Help by the Home Office once your asylum support is discontinued, and Migrant Help can provide you guidance on the voluntary return service, signposting to a legal representative if that is required, checking eligibility for Section 4 support that is eligible for people who are refused asylum, signposting to other organisations if you have received a Section 4 discontinuation for assistance with asylum support appeals. Now, you should have received information from your legal representative or the Home Office or court setting out the reasons why the Home Office believes that you do not meet the grounds for asylum or humanitarian protection. Migrant Help will receive notification from the Home Office that a negative decision has been made on your case and your asylum support has been discontinued, and we will contact you within 1 working day of the notification being received, and will confirm whether or not you want an appointment with one of our experienced advisors to be able to help you. And that is all. Thank you very much for listening, and we hope you found this useful.